Today we're going to discuss a few topics which are very common for, I think, everyone with a different background. So welcome to join, and today we're going to discuss the following legal topics. So today we're going to discuss a few topics I think you may be familiar with. The first one is contract law. The second one is consumer law. The third one is intellectual property law. And the fourth one is criminal law. And then the last one, which we will discuss, is internet and social media law. Last time we already discussed a bit about consumer law and the remedies you have under consumer law. And I think this presentation is easy to understand for all students from a different background, but I think it's very common. So I hope you will learn a lot from it, especially from the part of contract law. And then maybe next time we can discuss the agreements part of the contract. Feel free, if you have any questions, just raise your hand in the chat and then I can answer them meanwhile. It's not going to the next page. Oh, there we go. So the first topic we're going to discuss is contract law for today. And we're going to discuss what is a contract and what are the key elements. And we will also discuss a bit how contracts are formed. And I will discuss a few examples of the most common contracts that I think you all may encounter, such as a lease or a phone contract, for example, a membership or a mobile phone provider, or a lease for an apartment. There are a few key elements of any contract, and I will provide you a description as well. The key elements basically mean that those four items they should be present in basically every type of agreement. And the first one is an offer, because you need an offer, a proposal from one party to the other party, and that indicates the willingness to enter into a contract. Because if I will offer you something without the intention to offer into a contract, there might not be a contract applicable in the end. So it means I have the intent or the will to enter into a contract with the other party. The second element is acceptance, which means the other party will agree and accept the terms and conditions of the offer, which will create a legally binding contract. So for example, if I will offer you a car, but you don't agree upon the price, there is not a legally binding contract created because you didn't accept the terms of the contract, meaning the price you didn't accept. And the third element is the consideration. A consideration can be different things, but usually it's money, because you have to pay for the services or goods you're buying from the other party. But it can also be a good or a service. So for example, if I need to find someone to help me understand mathematics, that means I will pay you to tutor me mathematics. So you will provide me a service and I will offer you money as a return. So those three elements are very important, and you can find them basically in almost every contract if it's legally binding. If you have any questions, please raise your hand. So how do contracts form? There are different types of contracts and there are different ways to create a contract. It also depends on the business you're in. If it's a family business, it may be completely different than when you are in business, because if you know the other party you're working with, it may be created in a different way than when you work for a very big commercial company. So there are different types of contracts, and the first one is an express contract, and that is created through a very explicit agreement, either orally or in writing, between the parties involved. And what does it mean? It basically means it is very clear what does the other party desire and what can the other party offer and what are the terms they can agree upon. So an express contract is basically pretty straightforward because it's very explicit. The second one is an implied contract. An implied contract is formed based on the conduct of parties, even if there is no explicit agreement. So an implied contract can mean that the parties do want to work together, but it's implied, so you can see and you can experience there's actually a contract that is binding for the parties, but it's not explicitly stated. An implied contract is still legally binding. Another contract formation is a lease, for example. A lease is a contract of, for example, related to a property or a piece of land. So for example, I am granting another party to use my property, but I will still be the owner of the property or the piece of land. So it's actually the right to use the property or the land. But the rights of the land or the rights of the property, the ownership will not be transferred to the other party. So that is a very big difference because that means you have the right to use. Another example could be a license agreement. That means I will give you the right to use my license, but the license will still be owned by me. You can see this quite often in intellectual property cases. And a phone contract is pretty straightforward, I think. Most of you will be familiar with what a phone contract is. It's basically an agreement between an individual and a telecommunication provider for the provision of phone services, and in return, you will most likely pay every month a certain fee for the membership. It's a bit slow at going to the next screen for some reason. So essential elements of a contract. In the simplest of terms, a contract is basically any agreement that is intended to be enforceable by law. There are a few things though which do need to occur before it can be enforceable by law, and we will get there in a bit, because the process of getting all necessary parties to sign a finalized agreement is called contract execution. And for a contract to be legally binding, it must contain a couple of essential elements. Like we discussed before, it needs to have an offer, an acceptance, and the intention to create a legal relationship, and a consideration, which usually is money. However, it may still be invalid if it's pushing someone, for example, to commit a crime, because that's not legal, of course, or if it's illegal, for example, to do anything like which is an illegal activity, for example, to grow marijuana, or if it's entered into by someone who lacks the capacity, such as a minor, or someone who is bankrupt because they don't have the power or the authorization to enter into a financial agreement, for example, or if an agreement was agreed through misleading or deceptive conduct, duress or undue influence. For example, if someone is very drunk or someone is under the influence of drugs and somebody is still pushed to sign an agreement, it can be deemed invalid because that person was not aware of what this person was signing the agreement for. So I'm wondering if any of you have ever encountered such an experience, or can you maybe name another scenario when an agreement is deemed invalid? I don't see any hands. Anyone has any idea when an agreement could be signed by two parties, but there is a party involved who was not really able to sign for a reason? No, I still don't see any hand. Oh, yeah, you can go ahead, Lakeram. I think you can answer in the chat, right?
Yes, the students can answer in chat. Here's Steve Kalpe. Can you activate your microphone?
So I've been familiar with contracts, and but what we use is a notary public in the absence of the other party in some cases, or power of attorney.
Yeah, correct. Sometimes you need the power of an attorney or you need a notary to have an agreement be declared valid. That's very, very true. And another example could be, I see, thank you for your answer. I see another answer, the boy is underage and he doesn't have the power or capacity to enter into an agreement. Correct?
Correct.
And another example could be if someone has a mental disorder, which is not enabling this person to sign the agreement. So that could be another example. So thank you for your answers and thinking along. Then we will now continue.
You're welcome.
So there are different ways to enter into a contract, like I just explained. The first one is pretty straightforward, which is of course a written contract, because if it's in writing, it's very clear for the parties involved what the parties agree upon. And the terms and conditions are stated in writing in the agreement. So both parties can go through the agreement and make sure they understand the terms and conditions they are agreeing to. But another way to enter into agreement is a verbal contract, and a verbal contract is still can still be enforceable, but it's more difficult to prove. Usually a verbal agreement is created because two parties, they rely on the good faith of the other party. And usually those parties involved, they have known each other for a period, such as family who are working together in a family business, or two good friends who've been working together as an independent contractor and an LLC, for example, and then they want to set up a company together. Then they think they know each other quite well, and then they will enter into agreements verbally because they discussed already a few things, how they're going to set up the company or how they're going to provide the services, for example, to sell goods on a global level. But this can really lead to problems on the long term. So I really recommend you to avoid any problems on the long run, is to always state the things you agreed upon with the other party in a written contract. Because if nothing is arranged in a written contract, it might be very hard for you to prove in the end what you have agreed to, especially if there is a dispute and you are having a discussion about what's been arranged and agreed upon previously, but you cannot prove it, then it's going to be very difficult to resolve the matter between the parties directly. And then sometimes a third party needs to be involved in order to resolve the dispute, which can actually cost more money and more time than is needed. So I was thinking maybe you can think along of two scenarios where a verbal agreement could maybe occur as well. Do you maybe have any experience, or maybe one of you is operating a family business?
So this is Chief Calpe again. Can you hear me?
Yes, I can hear you. Thank you.
So I wouldn't call this a family business, but it's having a trust. I have more than one trust, and then I have a management trust, and that could
Yeah,
be a family business, and because all the assets has to go in the trust name, the various trust name, and then you manage it from the management side of it. So that I have, and
yes,
I work that. I use that. So
yes,
and
correct.
then
That
go
could
ahead.
be considered a verbal agreement as well, because that's the way how you will put the assets into the trust. And that's something most likely you verbally agreed upon, but maybe not everything is agreed upon in writing. So it might be more difficult to prove, but if it's something which is common behavior, because the parties already have been operating like this for quite a while, it becomes a verbal agreement as well. But if there are, for example, transactions which occur frequently, you can still try to prove in the end if there's going to be a dispute. It's usually related to either friends or family, or maybe a startup company. A startup company can also hire people in the beginning, and then they might hire independent contractors verbally before they're going to provide them a written contract, because they are trying to, for example, cut the costs. They want to check if they can make the profit, so they might work with people through a verbal agreement, and then later when things become more professional and they expand business, then they will work with a written contract. So that's something which you can consider, because a verbal agreement doesn't mean it's not valid legally, but it's more difficult to prove. And even if it's verbal or written contract, it still needs to contain the elements to be legally binding. And that is, it has to contain an offer, an acceptance, an intention to create a legal relationship, and a consideration, which usually is money.
Yeah. Thank you.
Thank you. So now we're going to discuss a business contract. What is a business contract? A business contract is a legally binding agreement between two or more persons or entities. An entity is basically another word for a company, because a business contract can be either from business to consumer or business to business, or consumer as well. And then dealing with contracts is a part of running a small business, but also of medium and big business, of course. And there will be different number of business relationships that will involve some type of contractual commitment or an obligation, because you need to put things into writing in an agreement with a signature of the parties involved to make it easier to prove, and also as a backup document. For example, if there is going to be a disagreement of what has been agreed upon, then you can go to the other party and you can show the terms and the scope of work, for example, or the liability, and then you can start the discussion instead of trying to resolve something if there is no proof. So for example, if you are a purchaser of goods or services, or a borrower of money, or you are working with rental agreements or a franchise company, then you will most likely work with contractual agreements. Also, if you're a supplier of goods or services, for example, dropshipping companies, a retailer, a wholesaler, or an independent contractor, those type of persons will also work with an agreement, because they will try to state in the agreement what type of work they will provide and what type of fee will be offered to them in return, the term and duration, for example, how they can end the relationship with the other party. But also, for example, if you will start a partnering agreement with another company, such as a partnership or a joint venture, then you will write things down in an agreement. Because if I will start a company with you, for example, based upon good faith, and we will both invest 200,000 euros, then maybe after half a year it's unclear what we're going to do with the profit of the 200K investments per person. So it's very important to think about the terms and conditions and the risks involved, or the challenges you might be facing on the long term, and put those things down in writing to avoid disputes as much as you can. Of course, you cannot avoid any disputes in the long-term run, but you can also modify the agreement. And this you can also stipulate in the agreement. For example, the agreement might be modified if both parties agree to the modification in writing. Or for example, you will review the agreement after the first 12 months together. Or the agreement cannot be automatically renewed after 1 year, because both parties need to discuss the agreement, and maybe they would like to update some of the provisions of the agreement. So it's very important to consider what is important for your company, what are the biggest challenges you might be facing, and what are the things you want to put down into an agreement. Even if you're a small company, it's important to think of the biggest risks involved, or maybe to limit the liability, for example, to the amount paid to you by that client in the past 12 months, for example. And also, of course, check what is allowed in your jurisdiction. So are contracts complex? Most people, if they think about a contract, sometimes they get the goosebumps because it makes them nervous, but it's not really, it doesn't need to be complex. It's very important to make sure that you fully understand the terms of the agreement before you will sign anything. Because before you will sign a contract, you have the time to read every word, including the fine print, and you must ensure that it actually reflects the terms and conditions that you negotiated with the other party. So, for example, if you enter into discussions and the agreement provided to you is not reflecting the terms, for example, the scope of work, as you have discussed previously, then you should discuss this again. Or maybe, for example, the people who might be hired to do the work, it's not negotiated before, or the skills or expertise you're looking for is deviating from the terms stated in the contract. You have to discuss this again before you will put your signature, because once you put your signature, it's more difficult to prove that this is not what you have discussed and agreed upon before. And also, if you do not understand any profession, it's important to seek legal advice to make sure you understand what is stated in the agreement, because sometimes it can be expensive to seek legal advice, because most people, they get scared of the attorney fees, but sometimes it will save you a lot of money on the long term, because if you do not know what you're signing, then it can become a very expensive business in the end. So I really recommend you to check what is in the agreement and what you are signing before you ensure that you understand what is actually in the contract. If you do not understand anything of the contract, please request the other party more time to consider and understand the contract. Because if you think, for example, if there is a profession you are not 100% sure of if you're able to sign this, because maybe your financial situation does not allow you to agree upon this, then you can also ask more time to consider and maybe come up with another solution. So don't be pressured into signing anything if you are not sure. It's also very important to never leave a blank space on a signed contract. So if there is a blank space, you can cross them out if there is nothing to add, so they cannot be altered later. That way you are ensuring there is not something added to the agreement at a later stage. And it's also important to request if the other party can initial every page before the signature page. This shows that the party has read and understood every page of the contract before the signature page is occurring. And of course, the last one is to obtain a copy of the signed contract for your records. Sometimes I see that people do not have a copy of the signed contract, and it surprises me, because it's utmost unprofessional to not receive a copy of the signed agreement, because you need to have the copy of the signed agreement for your own personal records. So if they did not provide you a copy of the signed contract, you have the right to request this. So make sure you do obtain a copy of the signed contract, because it's important to keep this as evidence, and also to make sure that you know what was in writing in the agreement in case of any dispute on the long run. So other examples of contracts, I think nowadays a lot of companies are working with influencer agreements. This is basically a legal document between an influencer who uses their platform to promote a client's product or services. Another one is signing a lease. We just discussed this one. For example, when you rent an apartment, or when you sign a long-term property lease, or maybe you want to sign an agreement to rent an office space, and of course the phone contract, which is one of the most common contracts nowadays. So maybe you're able to provide some examples from your own life, or maybe you can answer the question, which items do you think are important to put in a contract? Perhaps, guys, you can answer me in the chat so we can go through your answers together. There are many items you can think of to include in a contract, but there are some which are deemed very important.
Okay, we have a question from
Yes.
Jimmy Ebby. Can you unmute
Sure.
your microphone? Jimmy Ebby. Okay, I'm seeing some answers down there. The name of the employer and the employee, object of the contract, validity.
That is all very correct. Of course, the name of the parties are important to include in the contract. Actually, the full details of the parties are important to include in the contract. For example, where is the person residing, or where is the office located, or the company number, the conditions and terms as well, validity as well, the time of the agreement, the amount to be paid. Thank you, guys. They are all correct. The type of contract, yes, that is very important. It's usually the name of the contract. Verify the legal names on the contract, yes, as well. And the signature of both parties and duration. All those items are very important to include in the contract, and all those items are, they should be included in the agreement as well. And the rates, correct. You can also include even the currency, not only the rates. Could be important if it's an international service, for example. With dates and witnesses. Witnesses are not always needed. It depends on the contract. You can ask a witness to sign as well, apart from the parties. For example, if it's a loan, it could be more common to do so. The objective of a contract, yes, as well. And the duty of station. Well, thank you guys for all your answers. They're all correct. If there are no questions, then I think we can continue to the next slide. So here are a couple of examples, and you guys already mentioned them, so thank you very much. The details of the parties to the contract, including any subcontracting arrangements. So for example, if I have a like an IT company and I work with subcontractors, it might be important that I am allowed to subcontract the work to independent contractors. This will be stipulated in the agreement as well. The duration or period of the contract, because the periods could be indefinite or definite for a contract. This must be included in the contract, because if it's indefinite, it should be stated in the agreement as well. The definitions of key terms used within the contract. So for example, if there is an agreement, usually it stipulates in the beginning of the agreement a list of definitions given, and the terms. So the terms could be used throughout the entire contract, and the definition in the agreement is the one provided according to the term and definition stated in the agreement. Another one is a description of the goods and or services that you will receive or provide, the payment details and dates, the key dates and milestones, for example, if there are items that need to be delivered. Also, if interest will be applied to late payments, that's also included in the agreement. Could also be stated again in the invoice. Required insurance and indemnity provisions, guarantee damages or penalty provisions. Bear in mind that penalty provisions usually are only valid if the parties agreed upon a penalty provision in writing in the agreement. If you want to agree upon a penalty provision, it must be stated before in the agreement, and both parties need to sign. It's very hard to enforce a penalty provision if it's not agreed upon by the other party. And most jurisdictions, they also state that the penalty provision must be it must be reasonable. So for example, the penalty provision must be related to the damage occurred because of the breach of the provision. So you cannot name any number typically just to win more money because of the penalty provision in the agreement. Another one could be renewal options. Could the agreement be renewed, and if so, how? What to do in case of a complaint or a dispute resolution process. For example, if there is going to be a complaint of a customer, they can maybe reach out to the support department of the company. And if there is a dispute between the parties, maybe the parties desire to first resolve the matter through mediation. And mediation is basically a procedure through an independent professional that will help the parties to find a resolution. And another one could be termination conditions. Termination conditions, they should be in the agreement. And they are very important because they will entitle you to terminate the agreement based upon certain conditions. It's very important to check the termination conditions if you're signing an agreement. Because, for example, if you're not allowed to terminate the agreement only when providing a 3-month notice. That could be a long period for you according to the agreement. So always please check the termination conditions, and if this is reasonable for you to request. And the last one could be special conditions. So for example, if you're working with special gifted children, and maybe you would like to include special conditions about behavior, or maybe people who are allowed to work with the children or whatsoever. So it depends on the agreement, but all of them are quite important to include in the agreement. And the special conditions, they can differ per industry. So the second topic is consumer law. Last time we discussed consumer law already a bit, so I'm going to discuss this a bit more briefly. I'm not sure if you were all here last time, and if you remember, of course, but consumer law is very important because it ensures that fair and ethical business practices are ensured, and that there are remedies available for consumers who have been harmed by deceptive or unfair practices. So we have, as a consumer, you have the right to safety, right to information, the right to choose, the right to redress, the right to privacy, and the right to education. This basically means that you have the right to have information about the product you're buying, and you have the right to choose the product. So it means you should not be manipulated to buy a certain product. You have the right to privacy. That means that you, as a consumer, if you're buying a product and you will provide your information to the company, they cannot just sell your personal details to any other company without obtaining your consent. And the reason must be stated for which your data is collected. So these are all very important items. The examples of consumer laws we discussed last time, these ones are the most important ones: the Consumer Product Safety Act and the FTCA. You can go through this later because the PDF file will be sent to you, so you don't have to make notes of everything. So what is a fair business practice? A fair business practice is essential for protecting consumers from deceptive or unfair practices. And these practices include, like mentioned before, clear and accurate advertising. That means you must be made familiar with what you're buying. So what are the details or the ingredients, for example? It must be showing proper labeling and packaging. So for example, if it's a vulnerable item or maybe something that is flammable, the packaging must be correct for the item you're buying. And the pricing must be honest and transparent. So it's very important that the company you're buying a product from is providing accurate information. And if it's defective or damaged, then they should offer a refund or an exchange. And they also should provide clear contracts and agreements as well if you're going to buy a certain service from them. So last time we discussed the remedies for harm caused by deceptive or unfair practices. We just named a few, for example, to request a refund or an exchange. For example, if it's a damaged product, then maybe they could give you the full amount of money back, or maybe they can exchange it for a proper product. They can also provide sometimes compensation for damages, such as medical expenses, and also civil penalties and fines can occur if it's a violation of a consumer protection law. So I'm wondering if there's any student here from last time, do you remember any examples of remedies if you have been a victim of an unfair practice? What can you do?
So if you have been a victim, let's see, Steve Kalpe looks like has his hand up.
Yeah, hi. Seems I'm talking a lot today, but your messages are quite interesting. So I would call myself a victim because I had a tenant
Yeah,
occupying my unit and did not. I had to go through the eviction notice through an attorney, and
yeah,
that was quite an experience. But I eventually got them out. But it damaged the unit. So in a case like that, based on your question, yes, I have had a bad experience there.
I understand, Steve. I'm very sorry to hear. Thank you for sharing your experience with all of us today. It can be quite difficult, indeed, to take that person out of the property, because it might be very difficult if they've been living for a longer period in your property as well, to remove them, especially if they damage the property as well, to get the money back. So I'm sorry to hear this, but thank you for sharing. It's indeed an unfair practice.
Yeah.
I'm not sure how you solve this problem, but for example, this is more a civil law and this is commercial law we're now talking about. But then you could, of course, sue the individual for the damages occurred. I'm not. I hope that was not necessary to get the money back from the damages that occurred. But that's a solution. Or maybe there was another party involved. How did you solve the problem in the end?
I just let it go. Actually, I'm doing a small claims. Going through the small claims department to see if I could recover some money, but
Yeah,
their limits are really low, 10,000. In the Virgin
10,000.
Islands where I am, so I probably just let it go, and because I just wanted back my property.
I get it. And also, if the other person doesn't really have the money either, then even if you pursue litigation, it might be very hard to get the money back in the end.
Yeah. Mm-hmm.
Well, good luck. I hope it will be solved soon. I'm sorry
Yeah.
to hear, but I hope it will be solved soon, and I hope the next tenant will not create the same problem.
Yeah, thank you.
Thank you. So a few of the examples of
Oh,
remedies
sorry.
we discussed last time for deceptive or unfair practices are class action lawsuits. For example, if it's a very big company that is engaged in a unfair practice, then you can maybe join forces together and start a class action lawsuit. Another one is an individual lawsuit against a company, but if you do this on an individual level, it might be more difficult if it's against a big company, because it can take a lot of time and it can cost a lot of money. Another example is a government investigation and enforcement actions against companies. Because sometimes, for example, if there are advertisements online, then the government authorities, they can check and review the advertisements, and sometimes the supervisory authorities, they can ensure that the advertisements are taken down from the domain who is involved in the unfair practices. So now we're going to discuss an example. I'm sure you all are familiar with the Hyatt hotels. So what happened here with the Hyatt Hotel, there was an attorney in May 2023, and he sued the Hyatt Hotel because he mentioned that the Hyatt Hotel was violating Texas consumer protection laws because they were marketing the hotel rooms at prices that were not available to the public as advertised. What was happening in the case, the Hyatt, they were charging consumers mandatory unavoidable fees, such as resort fees, destination fees, or amenity fees, in addition to the daily room rate. So for example, if you're looking for an hotel room, you can see the room rate online, but once you check out for the room and you have to pay for the room, there are extra costs involved, for example, to use the in-room Wi-Fi or the gym or other fees, which were not presented before. So he started the case against the Hyatt Hotel because he said that the fees were not shown before. So it was an unfair practice because the consumers, they couldn't see what they had to pay in the end. And even when these fees were eventually disclosed, they were done in such a manner that it was unlikely to alert consumers that the initial rate was attracted, was not in fact the actual price of the room. So I included the link here, and here you can read the full petition of the case if you guys are interested. So it's actually related to overcharging or price fixing as well, because if you get the idea that you can book a room for a certain price, but extra costs are involved and you're not using the amenities, then it might be overcharging. And as a consumer, we usually check the price of a good or a product That's why the price is very important to mention in a transparent way. So you know what you're buying and you know the fees stipulated for the product, and that the fees are not hidden or undisclosed before you are signing the agreement, for example. So if a hotel advertises a certain nightly rate, but it fails to mention a required resort fee, there is an element of deception for consumers. And this can affect business owners who work with vendors or contractors as well. Another example is commercial misrepresentation. For example, if you buy a car, it's quite typical to ask the vehicle's accident history, and if the dealer lies about the history that is leading you to purchase the vehicle, you may have a misrepresentation case on your hands, because the person did not represent the product as it in fact actually is. Because, for example, if the car already had 3 accidents in the past year, but he told you no, the car is perfectly fine and nothing happened to the car and nothing is broken, then you buy a car without actually being aware of what you're buying. So it's very important to know what you're buying, and you should know that the statement is not false. Because if it's false, they could be liable because they have been misrepresenting the product to you. Or another example is a scammer. Scammers you can find a lot online nowadays, unfortunately. For example, people who are reaching out to other people online through dating websites, and then they're trying to get money from them by building up a personal relationship with them through the chat. So we also have unethical advertisements, and this example is from a female, and the advertisement says, "Are you ready for the beach?" Or basically, "Are you beach body ready?" And this advertisement was from a supplier in the protein world. And this advertisement was deemed unethical because it created the image that people who were not as skinny as this woman were unhealthy. So this advertisement, they got a lot of money from the advertising campaign, but it caused a lot of controversy around the world. So it still managed to boost the company's sales, but these type of advertisements are also deemed unethical because it's not realistic to advertise the product with such an image, because if you eat proteins every day, it doesn't mean you will get this body. So the third topic we're going to discuss today is intellectual property law. We discussed this before, but I want to go through it briefly today because those are quite common as well for you. And the first one is copyright, which is a legal protection that gives creators the exclusive right to original works. The second one is a trademark, and a trademark is basically a symbol or name, a phrase or a logo that will help you distinguish a particular product or service from other products in the market. The third one is a patent. A patent can protect your invention or discovery. And the last one is a copyright. And copyrights are very important because if you will use someone else's work, for example, you are conducting plagiarism, and that's the unauthorized use of a product which is copyrighted. So for example, if I will copy paste someone's book and I will start selling the book, and there's copyright on it, then it's copyright infringement and you will be liable for fines. So IP law is intellectual property law that's protecting the creation of the minds, such as inventions, trademarks, and copyrights. And patents, trademarks, and copyrights, they provide legal protection for different types of intellectual property. So the fourth topic we're going to discuss today, I don't think we have a lot of more time, so we're going to discuss this briefly, so we have some time for the questions in the end. The fourth topic is criminal law, and the difference between criminal law and civil law is that criminal law is between the government and an individual or entity, and civil law is the law between individuals or organizations. And common crimes, for example, are underage drinking or drug possession or assault. And there are different key concepts to think of if you are thinking of criminal law. And the first one is actus reus, and this is a Latin term that refers to the physical act or conduct that constitutes a crime. And it's the external element of a crime that can be objectively observed. The second one is the mens rea, and that is the mental state or intention. So that's something you cannot really always see. It is the guilty mind or the wrongful intention to do something, to establish a criminal activity. And liability in criminal law, liability refers to the legal responsibility for committing a crime. So criminal law helps you to be protected against an individual or entity. And the government will help you to be protected, and it includes crimes such as theft, assault, and murder. And the burden of proof lies with the prosecution to prove guilt beyond a reasonable doubt. So there needs to be more than only a reasonable doubt in order to be pleaded guilty. This is the last topic we're going to discuss. It's internet and social media law. And there are different laws online that will help you to govern the collection and use of data, for example, because many people, they nowadays work online and many data is shared. So there need to be laws enforced in order to protect your data as well. And you should be aware of the privacy settings and permissions on social media as well to protect your information. An example, unfortunately, nowadays is cyberbullying and online harassment. And there are laws against cyberbullying and online harassment to protect you from harmful and abusive behavior on social media platforms. And these are other examples as well. So for example, this could be done to intimidate a person, that they will use your pictures and they will publish this in order to get money from you or to harm you or to bully you. And there are copyright and trademarks laws as well to protect internet content like your images or videos or written works. And it's important to respect the intellectual property rights of others and obtain proper permission before you use any copyright or trademark material, because otherwise you may be liable. So internet and social media law deals with legal issues arising from online activities, and it covers different areas such as privacy, defamation, and intellectual property infringement. And it's very important to be aware of the legal implications when using the internet or social media platforms. Or if you want to set up a social media platform, for example, maybe you want to run a business and you will allow a chat online. So what type of online rules do you think could be created to protect you and others? Do you guys have any idea what rules could be created and enforced to make sure that people will be respectful online? For example, if you have a online casino, then what could you do in order to try to prevent bullying or?
Well, you can establish a filter to filter out certain words.
Correct, Dr. Lambert, that's a very good example. Thank you. Anyone else has any idea? I see one hand raised. Can you maybe unmute yourself so we can hear you?
Hi, Professor. Good morning.
Good morning.
I had one case whereby it was, in my country here, it's a big problem, whereby people get in touch or get in contact with other people's phone and they leak, nude pictures, videos, and when the law decides to apply or do the application, it's very hard because sometimes that person claims that it's not me, but the information was from their phone. So how we work with that?
So thank you. So you are saying that the defamation was coming through the phone, like the electronic device, and not from the person behind the electronic device. Is that correct?
Correct.
Then if the phone is his belonging, then how can he prove it wasn't him, but just the device? Did the device have any error, for example? Can he prove that the phone was, for example, hacked or something else?
No proof of the phone being hacked, but the information just leaked. I don't know if the person who were sleeping and they hacked the password, but there was no information that that happened, but the person was prosecuted because of the information that they leaked.
Yeah. Yeah. So it also depends on the type of information, but if the information was leaking from his personal device and it's his he owns the device, then he could still be liable because the data is stored on his device, and the device could leak information if it's hacked, for example, but then it's something you have to prove. Or if maybe you shared the password with someone else, but if I share my password with someone else, I can still be held liable because it's my device and I shared my password with the other party.
Okay. Okay. All right. Thank you.
Thank you. So anyone else has any idea of online rules that are there in order to protect you from certain behavior? I see also one question here. So what is the difference between criminal law and civil law? So the difference is criminal law is focusing on criminal activities. So for example, it's the government that is protecting you from other parties that are doing something criminal. So it's the prosecution who needs to prosecute a party. You cannot prosecute a individual if you're not the prosecutor. Civil law is between individuals, so different persons or entities. Criminal law is between the country's government and the person involved or the entity involved who is committing a criminal offense. That's the difference. So I see another answer: don't share harmful videos or sharp words to people wherever they are. Yeah, that's true. So what I was thinking of, maybe you are familiar, it's called, for example, code of conduct or online rules, for example, in order to ensure that people are respecting each other and that you cannot use bad words online or bullying or certain behavior. And if you do, then, for example, your account could be suspended or terminated. Or maybe you could maybe banned from access to the website forever. So I see another question here: how is the degree of harassment which can be punished? That differs per jurisdiction. So to answer that question, you have to check the laws of the jurisdiction itself. So I think we're almost at the end. So we will now discuss the conclusion, and then we have some time for questions. So contract law is basically legally binding agreements between different parties, and there are different key elements to include in a contract, which is an offer, acceptance, a consideration, and the intention to create legal relations. Consumer law, like we discussed, helps to protect consumers from unfair practices by businesses, and it covers areas such as product safety, advertising, and consumer rights. And you as a consumer, you have the right to information, the right to safety, and the right to redress. So thank you all for being here. We have a couple of minutes left if you guys still have any questions. I hope you guys learned from this presentation, and if you have any recommendations for a next presentation, please let me know.
I think we have a comment from
Hi.
Steve Calpe.
Yes, I have two questions. You referred to earlier that each page in a contract needs to be initialed. The reason for that is, and you mentioned, could one of the other reasons that you mentioned is that each page in that contract should be initial to ensure that the individual, so that no pages can be changed after the
Correct.
contract. Yeah.
Correct. Yeah, correct.
Okay. And in the case where you have an elderly person like 75, 80 years old and writing a contract, how do you confirm that that person is of sound mind to sign that contract? Do you have to
So
get sorry, go ahead.
your question is, Steve, to if a person is 85 years old, how can you make sure this person is signing the contract?
And
Can you?
their sound in mind.
Well, they should be sound of. They should be. They should have the clarity. I'm not sure if you have met this person or what the type of agreement is, but you could also try to reach out to this person and have a conversation with this person to ensure this person is capable of entering into the agreement. If it's for selling a small product, for example, then you could be thinking that this person is capable of buying such a product. But if it's, for example, buying a house of 5 million, then you as a professional, when this person might be 85 years old, then maybe you should conduct a bit more of research to check if this person is capable to enter into the agreement.
But do I?
Because
do
if
I,
you, sorry.
Sorry, do I get a professional to confirm that, like a doctor?
No, you don't. You can request this, but if you don't have any alarm bells ringing, then you don't need to think automatically that this person is not capable of not entering into an agreement. But if it's a special transaction for this person to do, because it's quite uncommon, for example, in general, then you as a professional, you should conduct more research. And you can ask this person as well for more information or try to have a discussion to make sure that the agreement is valid. Because if it's not valid in the end, then you as the professional party selling the product or service still might not be signing a valid agreement. So if you think the person may not be capable of signing or entering into the agreement, I will definitely research this.
Okay, thank you.
Thank you. We still have 1 more minute left, so I want to thank you all for being here today. And if you have any questions, then you can send me an email, or Dr. Lambert, maybe you can share my email with them.
I do not have your email. Can you write it into chat to everyone?
Sure.
And in the meantime, Herbert has a question. Asuko, Herbert.
Thank you, Dr. Lambert.
Hello, good
Please,
day to you.
Yeah, my question goes this way, based on the question just asked. If there is a doubt or there is a challenge of knowing that the person that is to go into contract is not sound enough, will it be appropriate to request that he should bring a witness or someone that can also surety for him?
Yes, you can ask to bring a witness, but for example, if someone has a mental disorder, then this person is not capable of entering into an agreement, and then this person has a specific person who is authorized to enter into agreement on behalf of the person being incapable of. So asking a witness could not be always sufficient, because sometimes a person has one appointed person who is the only person allowed to enter into an agreement.
Okay. Okay, thank you.
Thank you.
Lynette Davidson, did you put your email into chat?
Yes, I did. I sent it to everyone.
Oh, there
Can
it
you not
is.
see it?
Is it the hello@legaljoy.co?
Correct. Yeah.
Got it. Okay. So if you have any questions as you're writing up your assignments and you need sort of to understand a certain detail that you're talking about in your assignment, you can send an email to Lynette Davidson at hello@legaljoy.co, and there you'll be able to clarify the questions that you have for your assignment. We have one more question from Frederick.
Yes, thank you. Thank you, Dr. Lambert. I had put a question on the chat box, but I think it was not seen. So what I wanted was to ask, like in contracts, most of the times, like I would take a situation that is just on my table right now, where we had a fixed contract, and in that fixed contract in our country, there have been devaluation that has taken place, and the contractor wants to ask for, adjustment of pricing and other things. So when we read the contract, we are not seeing anywhere where we can help in such matters. But I just wanted to get clear to say, how do you treat such unforeseen issues that are coming within the fixed contracts?
So if the pricing is changed during the duration of the agreement, you can still agree with the other party that, for example, the price is subject to an annual increase because of the inflation, for example. You can still deviate from the agreement if both parties agree upon the modification. And the agreement you're signing in first instance, the initial contract, I recommend that should be always open to modifications to prevent the situation that you're not able to modify the agreement. The worst case scenario, if the other party is not willing to agree upon the increased price and you think this is reasonable to ask, then you can also, for example, terminate the current agreement and then sign a new agreement with the other party.
Okay. Thank you so much for that guidance. Thank you.
Thank you. So thank you all for your time today. And if you have more questions, please